well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Second Amendment.
Thanks for joining us again. Joe here with Leigh, and we're real excited about our guests today. We're at the law office of McDermott and Associates.
McDermott Law Group.
McDermott Law Group with Dave McDermott and Paul Piro. Gentlemen, thank you very much for taking the time and allowing us to come in and have some conversation with you guys. I guess, Paul, right off the bat, I have a question that I typically ask is, what does the Second Amendment of the U.S. Constitution mean to you?
Well, to me, it's how do I put this? It is very important to me because I do believe that people should be entitled to have firearms for their own protection as well as the protection of other people. You know, especially with the rise of violent crime. If you look at the statistics, the amount of robberies going on right now in Chicago, you know, I think more people are arming themselves now than probably before just based on the amount of violent crimes and the fact that they're trying to restrict this, restrict people's rights to defend themselves and their loved ones is crazy to me, but unfortunately those are the times we live in this political climate in Illinois.
Right. Gotcha. Dave, are you in line with that? Is that about mirror your image or your thoughts?
I'd echo that, but first and foremost, our firm has a focus on representing people that have been involved in self-defense shootings. So when we talk about the Second Amendment, obviously the Second Amendment is quite a bit more inclusive, but for purposes of what we do and what it means to me, Paul hit the nail on the head because it is such a significant right that we have. It's such a significant right, and it transcends so much with respect to what's happening, you know, in litigation affecting people's rights, and with respect to firearms, respect to carry, with respect to what they can and cannot carry, where they can and cannot carry it, and what they can and cannot do with those firearms when they're being attacked. So it's a narrow focus for me as far as what it means to me because we're immersed in that type of litigation on a very consistent, very regular basis.
Gotcha.
Before the interview, I was sort of just sketching out what potential conversations might be, and so I just sort of jotted down the principles of self-defense, legal self-defense, and the question that I sort of was, because you're so busy with specifically these kinds of cases, and specifically in Illinois, which the people that are trained in personal protection are from the state. And I was just wondering if you've detected any patterns where, you know, what element of self-defense do people get themselves in trouble? Where do things go sideways the most? Is there something that you see, or is it pretty much like a scatter plot where it's like all over the place? Sometimes it's proportionality, and other times it's, you know, you should have been better at preclusion. Like what do you see?
Well, I think it's a lack of education and training in many respects, but it's also a very disturbing political climate right now that surrounds us and what we do. As Paul had touched on, there's a lot more crime nowadays. I think last year there were over 29,000 carjackings or thefts in the city of Chicago.
Wow. So
I want you just to think about the significance of that, and I could be wrong, I'll double check, but I think it was last year it was over 29,000. So that's and I did a video on this not too long ago. So I believe in educating the general public on this, which is why we're here while we're talking. But you have to step away from that statistic, from that fact rather, and you have to look at which is significantly higher than it's ever been, right? And you have to look at all the restrictions that we have on law enforcement and what law enforcement can and cannot do nowadays.
Yeah.
So, and it's the people that are writing the rules, so to speak, have so much ignorance towards firearms and towards a lot of things that they're writing the rules about, but specifically about firearms, you know. And so we have all these different laws that are more or less empowering criminals and at the same time taking away the rights of law-abiding citizens. And I'll expand on that in a minute. But I want to just say with the 29,000 plus carjackings and or thefts in the city of Chicago last year, I think there was right around 2.5% of those people got arrested. So, when you tell police that they can't pursue vehicles that are beyond a certain speed, you're telling criminals at the same time to go beyond that particular speed.
That's
when you tell people, hey, look, we're going to, for example, we're not going to charge you with retail theft until it's above and beyond. A lot of states are going to $1,000, where you're really where the difference is going to be between any significant charging, where you're getting a felony, for example, and so until you've got criminals that are also being told this, and they're basically taking their calculators there and adding up what the heck they're going to steal, because they know they can go ahead, try to steal it, and run out of there. In worst case scenario, they're going to get a slap on the wrist. They'll be put back on the street, and maybe they've got a court date for a misdemeanor case because they know what they can. We're empowering, and I don't want to sound like I'm cynical, because I'm really not. I'm an optimistic person, but I am forced into a reality in what I do, specifically with respect to self-defense, when people are being approached at these situations, when they're being robbed, when they're being carjacked, when there's somebody's trying to enter their home and they're defending themselves, or somebody that they love is being attacked and they're defending themselves with their firearms, and they're being criminally charged, and you're going from a victim to a defendant in a matter of seconds, sometimes in milliseconds. And it's so, I think a lot of that, really, Leigh, with what you were asking me, a lot of it is like, it's the political climate. It seems like there's so many people that are anti-firearm because, again, of all the ignorance surrounding firearms. There's so many people that are anti-firearm that they are punishing anybody. The focus is on punishing people that are exercising their rights to bear arms. So when you talk about Second Amendment, I tell you, it's really focused out of this office what Second Amendment means to us.
Yeah, well,
it's because that there's all these restrictions now. I mean. And then you've got this ignorance that surrounds it, like, and I don't want to start preaching to the choir here, but just with assault weapons in general, what the hell is an assault weapon? I've got a water bottle in front of me that arguably could be an assault weapon, and the way that we define assault weapons in the assault weapons ban, in the PICA, the Protect Illinois Communities Act, when you're going through all these different definitions and labors of definition, you've got things that are being defined in such a way that I can make an argument that, when you talk about modifications, I can make an argument that a squirt gun could be considered an assault weapon based on the way that they've got certain things laid out in these laws, that they have. So I think that that's also affecting everything quite a bit with respect to that. Paul, you could weigh in on it.
My position is where things go wrong is I just think they're charging way too many people, way too many law-abiding citizens that are defending themselves or family members, and I don't think that it's the fault of the person that was doing the right thing. I just think that there's such a presumption that the person using the firearm is the one that was in the wrong, even though they were trying to prevent something, worse to happen. But because it involves a firearm, which is a very hot topic politically, I think that it's supposed to be innocent until proven guilty. That's
right.
The presumption. But unfortunately, when you use your firearm to defend yourself, in my experience...
And stop right there. What do you think he's about to say? Instead of it being innocent until proven guilty, what do you think he's about to say? What do you think, in our experience, it actually is?
That there's some kind of presumption of guilt because a firearm was involved.
So finish it off. Instead of innocent until proven guilty, it's blank until proven what?
Guilty until proven innocent.
And that's the crazy thing about it. It's not guilty until proven innocent from our perspective either. From our perspective, it's guilty until proven not guilty, which is a very dangerous thing. So for people that don't really know about the law and how the law treats these situations, for people that live in states where there's supposed to be a certain immunity after you defend yourself, if you defend yourself, if you exercise self-defense in defending yourself against an attacker, you're supposed to be, in certain states, you're supposed to be immune from civil prosecution, from a civil lawsuit. Okay, you're not supposed to have.
Is that not the case here?
But that's the problem, because arguably, say Illinois, that is the case. But what you have to understand is, as I just said, and it's a fine line, and people don't really understand it until they're involved in a situation like this and they're being tried criminally and sued civilly. You can be found not guilty. You're not found innocent. The judge or the jury, whoever's presiding over your case, whoever the fact finder is for your particular case, is not saying, we, the jury, find John Doe innocent. That happened some time back, and it's still in certain states they do have a finding that
I
effect.
gotcha.
But instead they say we're finding John Doe not guilty. So not guilty not being the same as innocent. And the reason not guilty is not the same as innocent is because not guilty means the state failed to prove you guilty beyond a reasonable doubt. Well, for criminal cases, that's the burden. For civil cases, it's by a preponderance of the evidence. So basically, instead of it being down here, the scale having to be really tilted one way or another, instead it's just a feather comes, just a hairline over. If it's just over 50%, so when they say you're not guilty, you might say, okay, well, I was found not guilty. I asserted self-defense. That must be why I was found not guilty. But there's not a finding by the trial court that you exercise self-defense. They don't say, we, the jury, find John Doe exercised self-defense and is not guilty. They don't say
Whoa. Wait a second. So in Illinois,
yes,
I get charged with a firearms crime.
based crime, murder,
Right,
attempted murder,
right,
aggravated
okay.
firearm.
I go through trial.
Uh-huh,
There's a decision made by a jury.
right.
My understanding was, prior to sitting here, that I did have some immunity if I was found innocent in that trial.
No,
Sorry, but I'm not. You're saying I'm not found. If I was found not guilty, sorry.
Correct,
So I'm found not guilty at trial.
correct.
I could still be open to a civil suit.
So here's the beautiful thing about this, because if you don't know already, and we started talking about this a little bit when we started talking about how you came to find out who we are, arguably you'd have a very difficult time finding anybody in this country that handles more self-defense cases than this firm, period. So I mean, let's just start there. So when I'm answering these questions, the beautiful thing about it is it's the buck stops here
Right.
type of thing. So
Right.
I'm telling you the way that it is. We have cases where we represent people criminal charges, and we beat these cases. That's another thing, because this is public record. You can look up the cases we're involved in. We're consistently winning cases. That doesn't mean by any stretch of the imagination that I can guarantee a W, but we're consistently winning cases. That's what we do in these self-defense cases. Over and over and over again, we win. That's what our reputation is for trying cases and winning cases. So we're consistently winning these cases, and we have clients that are being sued civilly still after the case is done, that the civil case against them remains in place, and that they're still going forward with the civil trial. We don't handle the civil portion of it,
Understood.
but we follow it because the attorneys for the civil portion of it contact us to get the evidence that we have in our
sure.
case and to get our perspective on it. So yes, the answer to your question is yes, you still can be sued civilly after you have been found not guilty after defending yourself with a firearm. And that's very, very crazy. That's why there's so many different layers
That
to
is
it.
very interesting, and that is something that my students who have trained with me do not know because I did not know.
Well, there's a couple other things that students don't know across the board, and I deal with a lot of firearms instructors all over the map. I've lectured in front of thousands of people all over the map, and I fight cases all over the map. This firm fights cases all over the map. And there's these laws change drastically from state to state, but not only do they change drastically from state to state, but because of the perceptions of what the legislators are doing in these various different states, the perceptions surrounding self-defense are very often skewed. So a lot of things that are being taught by firearms instructors, for example, are not necessarily correct. And there's also things there's also things that are very scary. Well, it's kind of, you say of course, but you think about the significance of this. The state is requiring you to be able to go ahead and obtain this permit. They're requiring you to have this 16 hours. They're requiring you to do all these different things, right? Mm-hmm. And so that you can say that you're not proficient necessarily, but so you can say that you have a certain baseline knowledge of what it is.
Yes.
Because the responsibility that comes with owning a firearm, right? Or carrying a firearm or using a firearm. So there are things, for example, like prohibitions on where you can and cannot carry firearms. It changes from state to state, of course.
Right.
And as an instructor, you know that with respect to a place that sells alcohol, you're going into let's say it's a restaurant, not a bar, because we know about the bars in Illinois. Which, by the way, there are certain states that don't have prohibitions against bars, but in Illinois, there's prohibitions against having a firearm in a bar. But I want to ask you this: you have a student that's going into a restaurant that also has a bar in it, okay? What's the rule of law? Are you familiar with the rule of law? Just, I mean, not as an attorney, but just as an instructor, not necessarily teaching firearms themselves, but just going through the concealed carry.
The Concealed Carry Act says that it's up to that business if they're making most of their revenue from the sale of alcohol, the majority of the revenue from the sale of alcohol, they are required to post the sign.
So 50% or more
Yep.
of the gross receipts in the last 3 months are from the sale of alcohol, then you're not permitted, regardless of whether they put a sign up there. You're not permitted. It's not, just to understand, the sign is something different. The sign means you can't enter the establishment if the sign is up. So they're supposed to be putting a sign up there, but they're not criminally culpable they're not criminally responsible for not putting a sign up. You, as the firearm owner now, have to understand how much it is that the sale of their what the sale of their liquor amounts to. So I want you to think
You can't possibly know that.
Exactly. So I want you to think about the significance of this. Joe, you want to say something, so I don't want to cut you off. What are you about to say?
I'm supposed to know what those businesses' receipts are?
Exactly. So you're so under the Concealed Carry Act, they say you cannot go into these establishments if, in fact, more than 50% of their gross receipts for the last 3 months are attributed to alcohol. Now, there's a presumption then. Well, hey, if that's the way that it is, based on my concealed carry class, they should have a sign up there. But not all these places put the signs up there. They don't want the signs up there. Not all these places subscribe to that mentality, so they want to put the signs up there because they don't want to lose business from the people that have been coming to their bars or their establishments for a long time that feel the same way they do about the ability to be able the right to carry.
Would you describe this as a difference between the letter of the law and the way the law is practiced?
No.
Or is it a problem with the letter of the law?
This is a problem with the people. This is a problem with the letter of the law.
Okay.
And I'm going to show you why it's a problem with the letter of the law in Illinois. This is going to blow your mind. We only have so much time to talk about this stuff. So every time you open up a question, you open up a can.
Right, of
Be
course.
prepared to go ahead and get quite a bit coming out of that freaking can. So here's the thing. Here's the thing with respect to this particular issue, and why I use this as an example. We have a guy that was just he was just charged with multiple counts of attempt murder, aggravated battery with a firearm, discharge of a firearm, reckless discharge of a firearm, and a UUW, unlawful use of a weapon, for bringing his firearm into a place that sells alcohol, a place that where people are consuming alcohol, despite the fact that it is not a bar. It's a pizza joint that has a bar in it, and you know what? They might have. Leigh, Joe, they might have the majority of their receipts, the 50+%. It's not even the majority, but 50, more than 50% of their gross sales attributed to are coming from the sale of alcohol. But here's the thing that you have to understand: he gets charged with all these different things. We beat the significant charges because, as I said moments ago, we consistently win these cases. We beat the significant charges, and then there's this fallback. There's this well, we're going to throw the state a bone to get the UUW thing. Here's why, though. Because the Concealed Carry Act in Illinois says what we just discussed. And again, as Joe says, how the hell am I supposed to know what their receipts are, right?
Right.
The Concealed Carry Act says that. But the Criminal Code of Illinois makes it illegal to bring your firearm into any place where people are consuming intoxicating alcoholic beverages. So the criminal code, the Concealed Carry Act, if in fact it was more than 50% and you have concealed carry privileges and you go in there, you can get charged with a misdemeanor. The criminal code in Illinois says for going in that same place, it doesn't matter whether you have concealed carry privileges. It is a Class 4 felony. So you go from a potential sentencing range of up to 364 days and up to $2,500 in fines to, instead of up to 364 days and fines, you go to a potential 1 to 3 year prison sentence and fines, and greater fines. So the thing of it is, what I'm saying is, it's not knowing the law is not enough, because you have conflicts within the law because of the times that these statutes were written, and they didn't in any way do anything to say, hey, look, this is how we're going to apply this to the extent there's any conflict. So this judge, we argued, hey, look, the Concealed Carry Act says this. If you're a concealed carry holder, he says, but look, and he's correct. The Illinois Criminal Code doesn't say anything about an exception if you're a concealed carry holder. It just says that it just says X, Y, Z, and apparently your client's in a place with X, Y, Z. So that's why he's got a Class 4 felony. That's why I'm finding him guilty. Now, we're appealing that. We're going to go to the appellate court, and I'm just going to say this in advance so people can listen to this afterwards. We're going to win, because again, that's what we do. But the thing of it is, I want you to understand: in the meantime, this guy's getting dinged with a felony,
Right.
for defending himself. Nobody would have known that he had the firearm on him. He ended up two different people were injured. The firearm was discharged 2 different times. I'm not going to go into the facts of the whole thing, but he's now getting charged with a UUW for simply. Let's go back to our very first question. What's the importance of the Second Amendment to us?
be able to protect
You
you.
know, I mean,
Yeah.
look at the fact that you are exercising your right. So some people argue it's a privilege. Some people argue it's a right. Look at the fact that you're exercising your right to bear arms. You're being attacked in such a way that, and that was a bench trial, that the judge agrees with you. And by the way, what's the standard for lethal force in self-defense? The standard for lethal force in self-defense is what? Let's just start with that. What's the standard for lethal force in self-defense? Does anybody really cover this? You ever really go into the definition of this?
We haven't gone into on the podcast
Okay.
the legal ramifications. So if you can,
Well, I'll
enlighten
share
us,
it because I
that'd
know
be
you know
great.
what it is, but I want so that people are hearing it from an attorney. The standard for lethal force in Illinois is would a reasonable person believe that he or she is about to receive great bodily harm or death. Now, in all these different states that I practice, that we practice, you know, it's pretty much the same definition. What changes really around self-defense when it comes to lethal force, what changes around self-defense when it comes to lethal force from state to state, because they might phrase it a bit differently, but generally speaking, that's going to get you through self-defense as a general
Kind
rule.
of a 50-state
and yes,
definition.
as a parameter.
Yeah.
But what changes here from state to state is how states perceive what your obligation is when you are being attacked. So, Paul, there are three different perceptions as it pertains to self-defense with lethal force, and when you can exercise self-defense with lethal force and be justified in doing so. And what are the three? Just give them three titles if you can.
Sure, there's to retreat states.
Yeah.
There is the stand your ground states, and there's also the castle doctrine.
Yep.
Now, what I want you to understand about that, thanks. What I want you to understand about that is that you can't have more than one of those in a state. So you can't have a form of castle doctrine in a state, and at the same time also have a duty to retreat and or a stand your ground
Stand your
law type of thing. But there's a lot of craziness surrounding this because I'm going to ask you this for the very first time right now, and if we don't like your answer, you know, you could go ahead and change it. But I'm going to ask you as I want you guys just to go ahead and do me a quick favor because nobody can see you. I want you guys to close your eyes. Don't look at each other, please, and raise your hand as to which one you think Illinois is when I say it. Okay? So and don't do it so the other person can hear. I just want you to just raise your hand. Do you believe that Illinois is a castle doctrine state? Do you believe that Illinois is a stand your ground law state? Do you well, if you want to change at any point, do you believe that Illinois is a duty to retreat state?
No.
Okay, well, you guys are a hell of a lot further along. Open your eyes, please. You're a hell of a lot further along. So, Joe properly said that it is a castle doctrine state, although you know people don't really truly understand that it is a castle doctrine state. And Leigh properly said that it is a stand your ground law state, and people don't know that. So, kudos to you guys. And I don't say that. I want you to understand the significance of this. I ask firearms instructors, people in the 2A community, this question all the time, and you'd be amazed at how many people get this question wrong. And I'm going to explain why, from experience, why so many people get this wrong. First off, many lawmakers, many attorneys that practice in defense, and many judges, crazy enough, guys, believe this is a duty to retreat state.
Really?
And that's
Wow.
baffling. But here's the thing. When I say I've lectured in front of thousands of people, I ask this question all the time because of how much it blows my mind. And I ask this question of the firearms instructors when they're in the room as well. And not to put them on blast here, not to necessarily point out the ignorance that surrounds this issue, because it's not deliberate ignorance. People are trying to educate themselves, which I appreciate, which is why I go out and speak to people. Most people, and even when you said when you raised your hand, Leigh, you said because it's just when you talk about stand your ground law and you're like,
Well, in practice.
it's in practice.
In practice.
You're correct.
Yeah.
It's in practice because most people don't know this. So, and because Illinois, because they are so anti-firearms, and not Illinois itself. I'm offending a lot of Southerners in Illinois. I'm talking about the politicians and the legislators, as a general rule, appear to be very anti-firearm. Okay, and so people take that and they perceive that to mean we don't have. By the way, we don't have stand your ground law. quote unquote. We do not have anything in our legislation that says stand your ground
Yep.
law. Okay, we do not do that. So people think, same thing with California. I finished a case out there in December, a self-defense shooting case out there in December, and the DA was arguing, hey, you know what, I want the defense to be precluded from having any mention of stand your ground law. And I said, well, why is that? She said that's not the proper that's not the proper standard. I said, yeah, that is. California has stand your ground law. But people don't perceive, and I posted a video not that long ago. I was just in Tahoe. I was posting some videos of some of the differences in laws affecting, Nevada and California as it pertains to firearms. And I had people saying, well, no, California is not a stand your ground law state. It actually is. Not necessarily through legislation. Some of these states, not necessarily through legislation, but through the judiciary, through the courts, which interpret the legislation, right? The courts interpret the laws, and then the courts make a determination as to what those laws mean. And Illinois has certainly said, the Illinois courts have certainly said that this is a stand your ground law state, and the same thing with California. And we also have changes in our laws, right? All the damn time.
Constantly.
So,
Yep.
you could be a stand your ground law state, and then you could have somebody come in and arguing there should be duty to retreat and kind of pushing some legislation through in that direction, and then changing the way that we proceed from this point forward. But a lot of people, guys, which I mean, congrats to both of you for whatever it's worth. A lot of people get that wrong. We do have some form of castle doctrine. I say some form of castle doctrine because that changes from state to state. In Illinois, in certain states, castle doctrine extends to your vehicle. It doesn't extend to your vehicle in Illinois. But on the flip side, if you're in your vehicle
Right.
and somebody is attacking you in your vehicle, it doesn't matter. I mean, it's a much smaller place. It's definitely the presumption is that you are reasonable in defending yourself if you're being attacked in your vehicle. But I mean, you have to think about, again, going backwards in this conversation, just talk about the significance of what I was saying with carjackings and or thefts in the city of Chicago alone, and how many people are getting in trouble. So you have to think these criminals, it's a free for all right now. I mean, they're having a good old time out there. It's Wild Wild West time.
Wow, there's so much.
And I just
There's so much we could talk about.
Yeah. Yeah.
Because my brain starts going, well, I'm thinking of the legal section of the concealed carry course I teach, and I've got the legalese up on the board from the various Illinois code, and so there's this section that I show to students about your personal property, and that if there's someone in the personal property, that it's similar to your home. Like if there's someone in the vehicle,
Don't do that.
and you're being attacked, that
if you're in there, if
Right.
you're in that property,
right. So
and they're
you're
coming in
inside.
there-
So does your vehicle count?
No, not as castle doctrine, not in Illinois. There are certain states where Illinois, where castle doctrine extends to your vehicles.
Right, okay.
Castle doctrine can extend to a number of different things. It can extend to your business.
But we're not
obviously.
really castle doctrine state either, are we?
We are in a sense, as far as what most people can relate to.
Because of the
most.
language
Most
of the law.
people can relate to castle doctrine more than they can relate to stand your ground law. Most people believe that it's duty to retreat, though. So I mean, it's law is very funny. What we do is very funny because law is constantly being interpreted and reinterpreted and reinterpreted. So,
Do you find, or do you see that clients get tangled up in that preclusion part of it, where you could have made better choices, you could have gotten away? Why didn't you do that?
well, this is what
Or
you
is
asked.
that? Because I really am interested.
It's
Like
kind of what you asked
I'm
at the
similar to you. Like you're very granular in how you approach the subject from your aspect, and I do the same thing in the training realm. I try to get so realistic with my clients and how they train and how I train them, that I want everything to be grounded as close as I can get it to reality. And so I really would like to be able to inform people, like where are civilians getting caught up? Is it in your reasonableness of how you acted? Is it in the proportionality? Is it in your you didn't try to make a better choice and
Rewinding the clock a
preclusion
bit.
part?
Rewinding the clock a bit, assuming that our clients or your students are getting caught up. As I said earlier in this conversation here, is a lot of it is from political influence and overzealous prosecutors, in my opinion. I think that I think that you can't prepare for that. You can't
Right.
prepare
You can't prepare for the fact that-
you can't prepare for people's
I see.
differences, and that's why I immediately answered your question earlier. Where people are getting caught up the most is really it's a
the
combination
climate.
of things, but I think it's the political climate right now.
I'm
more
starting.
than anything
I
else.
see now. I didn't see
Because
before.
of that
I'm
reason.
starting
Another
to see.
thing, Paul's an attorney in this firm as well, and the reason I asked him to sit in because he just did another detention hearing today. And for those of you that don't know what a detention hearing is, we in Illinois, we have this Pre-Trial Fairness Act, the PFA, Paul, I want you just to expand on what the significance of PFA. Not today's client, but no specifics. Obviously, here, guys, for purposes of today, we can, sometimes we share things with cases that are behind us that I think people can learn from in these types of forums. But I want to talk about the significance of what's happening. First off, Paul, just describe the significance of the PFA, and specifically as it affects the 2A community when they've been involved in a self-defense shooting, because otherwise there's a lot more to the PFA. It's just like there's a lot more to the Second Amendment. So if you could just share some of what we're dealing with the PFA.
Right. So in order to understand the significance of the PFA, we have to first understand what the PFA is and why it was enacted. So Illinois used to be a cash bond state where, even on a very serious charge, chances were that you would probably be given some sort of monetary bond. Not every single time, but a lot of the time. And they've done away with that. And, we can have a separate discussion about that. But how this affects people is now you're either being detained or you're being released. And there is no option. So, like on a case, let's say you're defending yourself and you get charged with murder or attempt murder or something like that, right? Chances are you probably would have gotten a monetary bond under the other system. And, now they don't have that option. So it's very difficult, from potentially a judge's perspective to justify allowing someone to be released on their recognizance. They might be concerned about the kind of political blowback or pressure that they might be having releasing someone charged with something that serious. That being said, now basically anytime you use your firearm, they're seeking to detain you. And if you look around, there are a lot of people being detained that were defending themselves. So, when you use your firearm, the prosecutor is going to make a very big deal about the fact you used your firearm and, provide what they believe to be what occurred. Obviously, they're not gonna say that you were defending yourself and things like that. They're gonna try to paint you as a person who is the aggressor, who was trying to shoot somebody or kill somebody, and it's making it very difficult for people because now they have to fight a case while they're in custody, and when they might not have done anything wrong in the first place.
Let me just expand on that. Do you know there was a recent article? I think you probably did read about it, but do you know, Paul, just to share with everybody, how long does the average, just in Cook County, which obviously, and the reason I'm referencing Cook County, this particular office of ours is located in Cook County, but Cook County is probably one of the scarier places to be in if in fact you're involved in a self-defense shooting for a number of different reasons. But do you know how long the average murder case takes to go to trial?
No idea.
I want to say for a Class X it's 5 years, and I want to say for a murder it's about 7 years.
Yeah, they did an article, I'm pretty sure it was the Chicago Trib, I'm not sure where it was, but I think it was the Chicago Trib that they did an article saying that it takes approximately 7 years for a murder case to go to trial. So I want you to think about the significance of this.
I am
Say you just put it all together very
Yes.
quickly, but just for everybody else that's listening that might not be, that might have just woken up at this part of the conversation, I want you to think about the significance of this. If you are, God forbid, in a situation where you are scared to death, you really believe you're about to die, you take your firearm out, you discharge your firearm, you shoot this individual, you kill this individual, you are now being charged with murder. You've got judges, just as Paul said, that are concerned about the blowback. Okay, no pun intended. They're concerned about the blowback here of what might happen if they release you, because this this abolition of this doing away with cash bail was under the auspice. It was under the premise of, like, you know what, we've got different people in different communities that can't afford the same bond. You know,
Right.
and there's that's a fair statement, guys. It's a very fair statement. There are people in certain communities,
Sure.
certain people that do not have the financial resources. Their families do not have the financial resources to post a bond. So even say it's a $1 million D bond, and you have to post $100,000. You know, there are some families that have the ability to get together. Their family has the ability to get together that money, or to refinance a house, or to empty a 401k, whatever situation it might be. They have the ability to get that, and other communities, other families don't. And for that reason, there's a strong argument there. And so that's the way they approach this, guys. But I don't think that that's what it was. And I'm not a conspiracy theorist, but just hear me out for a second. The law has always been that bonds are not supposed to be oppressive.
Right.
So if the law is truly followed, and a judge sets a $1 million D bond here, and the family posts and sets a $1 million D bond here, and this family can't afford it, then by law, the judge should reconsider his or her bond.
Sure.
And should reduce the bond and afford that person an opportunity to be able to go ahead and get that money together and get out and be on bond while the case is pending as well. But instead of it being to balance, because we already had a law in place to balance. If people are like, this is not fair, then people should have said, well, then we should make the judges enforce or attorneys that are arguing for these people, you know, a bit more cognizant of what the law is, so that it can be the bond can be reduced.
Make an adjustment,
to
sure.
accommodate these people that don't have the wherewithal. And certainly you could show they don't have the wherewithal because they've been sitting in jail for months waiting for their case, and nobody wants to sit in jail.
Right.
So, but instead they push this agenda here, because I want you to think.
Yeah.
about
Are you
this.
going to go back to the paranoid guy? Because I like that guy. So
I want you to think about this. Though.
yeah. So where's it come? Well, like,
Here's what happens.
yeah. Is it
They-
ignorance and they
they-
put forth a law that sounds good, or is there?
There's a certain amount of blame on all sides. The people that there are people that stood behind this.
Because I don't think the public knows what you just said.
True.
The
But
public is ignorant, so
and
they
many-
didn't.
true.
I
I
know,
know.
so-
You know, if you know, we all have our niche, our areas of practice in life, right?
For sure.
Whatever it is that we do for
Yes,
a living,
yes.
we all have our areas of practice. And true, I don't expect everybody to know the law, but I want you to think about the significance, the overarching, the larger picture here. They enact this law saying we're going to do away with cash bail, and they tried this a couple times in a couple states, and it went absolutely nowhere. It went nowhere. They tried it here. It was supposed to go into effect, I believe, January of 2023. It was shot down in December of 2022 by a Kankakee judge that said it's unconstitutional as it violates separation of powers, because you can't have the legislators telling the judiciary what the legislative branch can't tell the judiciary branch what the heck they're going to do with the release of people that are on trial before them. So it was shot down. It was challenged. It could have been challenged for a number of different reasons, but that was the main challenge. It was shot down, and then they went back and forth, and then the Illinois Supreme Court said, no, this is good law. We're going to keep it here. Okay, so it's enacted officially as September of this past year, of September of 2023. There are no other states doing this, guys. So when you talk about something called stare decisis, that's case law, to rely on case law, to look to get a frame of reference, to get some sort of dicta, to get some sort of position to support your position, some sort of legal position. You, generally speaking, when you want to be able to assert a legal position that's not typically argued, you go to the case law, you go to the appellate court and Supreme Court decisions. So, but there's nothing before September having to do with this no cash bail detention stuff. So they've got a lot of people that they're detaining all of a sudden. And we have very little law for a couple months because we're waiting for the results of the appeals that we put through as criminal defense practitioners to be able to have the appellate court or Supreme Court eventually weigh in on this. But I want you guys to think about what's being done. They do away with cash bail, and then they have this small print. Because that's the law, has a lot of small print, right? They have the small print. And the small print says, among other things, that if the person being charged is a danger to society, really that's what it's saying, okay? Paraphrasing. But if the person being charged is a danger to society, if the judge believes this person is a danger to somebody else in the community, then since there's no more cash bail and everybody gets out, this is an exception. You now cannot post any monetary amount. Instead, you'll remain in custody until your case goes to trial.
Those 5
Now,
to
I
7
want
years.
you- yes, well, 5 exactly, which is why I asked Paul. So I want you to now. I want you to let's just grab this all this information, just haul it back in, and I want you to think about the true significance of what we just talked about in Illinois, of all places, because you start off, really want to talk to people in Illinois, but this is something that's going to spread like a cancer. Watch, there are other states that are watching what's happening in Illinois so they can justify this. And they're going to present it in the same way Illinois presented it. And they're going to say, look, certain communities, certain individuals can't afford cash bail. And we have to do something about this.
Is there case law to look at
Watch it
outside the United States where there's
It's not-
no
it's-
bail? And if there was, it wouldn't be relevant.
It has,
anyway?
no, it has, nothing, it
No
has
bearing
no
on it.
bearing on anything anybody in the United States does. No judiciary in the United States.
I was
is
just
gonna say,
wondering,
well, this
you know,
is
like,
what they're happening.
If you can't
it's
find it,
happening
I
in
was just sort of
Germany.
thinking, like, you
No.
go elsewhere.
No.
Yeah.
So, I mean, now we have to compound these other issues that we already have in place. If you take you God forbid, are put in a situation where you do in fact have to defend yourself with your firearm, and you do in fact do so, and you're being criminally charged, now you have to worry about whether you're going to be sitting in custody the entire time until your trial goes forward.
Yep.
And do you know what's the craziest part about this, which we didn't inject yet? Is prejudice. All the people that prejudge.
Mm-hmm.
Because people inherently prejudge. We're imperfect. We prejudge.
Sure.
We judge people in situations all the time. We do that. And so you've got all these different, I want to hear what you're saying. I just want to say this very quickly, Paul, because I can tell you want to say something. We have plenty of stuff to say on this, as you could tell. I'm sure usually you're the ones asking quite a bit of questions, and now you're just.
I'm fascinated.
No, I don't care.
But I want you.
good.
But I want
We're
you.
good.
I want you to think about what I just said about prejudging. You not only have to be concerned about being attacked, you not only then have to be concerned about the system now attacking you, but you now have to be concerned about where you're being charged, and the potential that the judge that's presiding over your case is anti-firearms. Is a
Right.
judge that says, you know what, you shouldn't have firearms anyway. You wouldn't be in this situation if you didn't have firearms. We'll get to whether you're guilty or not guilty, but the reason you're here is because you killed somebody because you decided you're going to leave your house that day with a firearm on your person. That's why you're here. So take ownership for the fact that you did that, because you're going to sit in custody until we make a determination as to whether you're properly defending yourself.
Let's hear from Paul, and then I'd like to circle back on that.
So there's a number of issues with this. One of the issues is, let's say that you suffered an injury during the act of defending yourself because someone attacked you, right? So now you've got a judge that is, likely detaining you, and now you've got injuries, and you might even have the sheriff's office potentially not giving you the proper treatment, which is another issue, and you're waiting for a trial for 5 to 7 years potentially on this. Another logistical hurdle that this creates is, in a self-defense trial, usually the defendant is going to testify, typically, right? And so it makes it harder to prepare for your trial while you're in custody. And depending on what county you're in, they might have limited hours you can visit your client. They might not be able to do Zoom meetings. And this is your life on the line. You're
Right.
potentially looking at life imprisonment depending on what you're charged with. This is just a nightmare situation to be in, if you happen to be defending yourself or someone else.
And that's not even to mention the negative impact on your personal life, such as a job, that may make it difficult to pay for a defense.
Oh yeah.
To
You have to have a defense. You have to have self-defense liability insurance, in my opinion. I mean, we talked about this, before starting. You have to have some sort of self-defense liability insurance coverage. You have to go with an organization, and there's a number of different organizations out there. We have our favorite here, but we deal with a lot of different people from a lot of different organizations. And again, some are far better than others. And
Do you have
people
a problem with saying your favorite and why? If you don't want to, I totally
Well,
understand. But
our favorite, I don't have an issue with saying what our favorite is as far as who we're dealing with from personal experience. I believe the USCCA is most on top of their membership and most on top of their membership's concerns
Okay.
and providing for their memberships for fees and everything else. And I say that from experience, from the number of different from who we represent from different organizations. I don't say that to badmouth any organizations, but
Yes.
I know that I don't have problems with the USCCA. There's different organizations that are mudslinging right now about
from your side as an attorney who would be looking to get paid, you don't have problems getting
Yeah. See,
what you need from the USCCA.
I've never had
to
an issue.
help a
So
client.
people say, well, they deny this, they might deny that.
I just
I've never-
watched a video today. I had a little bit of time between the end of the workday and coming out to see you, and I watched a video, and the guy was bad mouthing the USCCA.
And I get that, and there's a lot of money to be made in this particular field for providing coverage for people because, again, there are that many more people purchasing firearms. There are that many more people using firearms to defend themselves. So there's a lot of money to be made. So there's people stand to gain quite a bit by bad mouthing other entities. And I'm not going to direct comments in any direction. This is not meant to be in the form of an advertisement for the USCCA. I know from personal experience, I represent a substantial number of their members, again, all over. And I know from personal experience that I have never, there's no exception, there's not been one exception, I have never had an issue getting paid or with them giving coverage to somebody that I've represented. So, and I'm not going to expand on just how many people I represent, how many of their members I've represented, but I've never once had an issue. So yes, from personal experience, because we can go off of what we know for a fact,
Sure.
not what we hear,
Yes.
not different people that are trying to poison the well, so to speak. But
That's
from
why I
personal
use-
experience.
That's why I'm here.
Yeah.
Like the
And
reason I
again-
do this is because this is the kind of information I think people deserve.
And again, find somebody that handles more of these cases.
Okay.
I mean, good luck trying to find somebody that handles more of these cases. So from personal experience, I think they're a hell of an organization, and the UFCIC, which is their Universal Fire Casualty Insurance Company, which is the insurance company that provides the actual insurance for self-defense liability for their members, is a hell of an organization as well. I don't have any issue with the USCCA with having communication with them regarding the members, and I don't have any issue with the insurance company that's providing the coverage for their members. And I know people say, well, hey, what about prohibited firearm locations? The USCCA doesn't provide that for their members. First off, again, it's not the USCCA that's determining what's covered and what's not. It's the insurance company that they provide, the insurance that they provide through the insurance company that provides it, that makes a determination. But I've never had the UFCIC say, hey, look, we're not taking this. And we've represented a good number of people, such as the one that we just finished. The person I was referring to is a USCCA member that has firearm in a place that he's being charged the UUW, and they never balked at the fees or about the bills or anything else. And as a matter of fact, although that's what he is being found guilty, he's not. The judge specifically said for everything that he asserted self-defense, he is found not guilty. This is not something you cannot assert self-defense on this, and there's no. The judge didn't believe there's anything he could do based on the way the criminal code is written, despite the conflict with the Concealed Carry Act. But that's what he's found guilty on. And guess what? The USCCA is paying for the insurance rather through the UFCIC is paying for the appeal for the USCCA member because they believe that this is such a critical thing for the 2A community to go ahead and address the conflict in the legislation that exists in the state of Illinois in this respect. So, yes, if I haven't answered that enough, I'm a very big fan of the USCCA and what they do. Guys, we talked about the laws and we talked about Illinois. I want to make sure I circle back on this because something you had said earlier, I think, Lee, you're the one who said something about this for something I was saying. We were talking about the legal climate and everything. And you talked about practicalities, and is it a practicality issue? there's a lot going on with as it pertains to practicalities. There's a lot of people, as an attorney, I have to advise people, we have to advise people to follow the laws, but we get more and more people that are like, hey, look, the signs, for example. The signs are posted. Criminals look at those signs that are posted on these businesses, and this is fish in a barrel.
Right.
That's what this is. They have an opportunity to go ahead and rob people that are on these premises because if they're not going to have their firearms. And to a large extent, for a long time, the 2A community is like when we say 2A community, we're talking about law-abiding citizens generally. When I refer to 2A community,
right.
I would assume we're all on the same page in that
Yeah.
respect.
Yes.
Absolutely.
And you're talking about law-abiding citizens. So law-abiding citizens are like, well, damn it, I can't bring my firearm in here. I either won't bring my firearm there, or I'm going to go somewhere else where I'm able to bring my firearm, right? Well, now you got people crossing lines because of how many signs there are. They're like, you know what, I'm conflicted. And they're like, you know what, I would rather take a chance taking a Class A misdemeanor, bringing my firearm into this establishment, if in fact, because concealed carry, if it's properly concealed, people aren't going to see it anyway.
Nobody's going to, right?
So I'd rather take a chance bringing my firearm into this establishment and knowing that I have the ability to defend myself. God forbid one of these criminals comes in there, because criminals are not going to be like, check the firearms at the door. Oh, hold on a second. This is a place I can't bring my defaced serial number. My firearm with the defaced serial number in.
Mm-hmm.
They're not looking at that stuff, obviously.
Did you have another thought behind that? Because there was a question and it's totally related to what we're talking about right now. I think it dovetails in.
Well, we'll bring it in. I wasn't. It wasn't another. I wanted to say with that it applies on numerous levels. It applies with the assault weapons ban. It applies with when in Illinois, for example, somebody approaching your police officer approaching your vehicle. In certain states, you're obligated to tell them whether you have a firearm. Certain states, you don't have to say anything. In certain states, like Illinois, you have to answer the question honestly if you have a firearm. Well, now people, because of the assault weapons ban, and you had 15,000 people out of 2.4 million FOID card holders in Illinois. And if people don't know what a FOID card holder is, if you're listening to this from out of state, because that's in Illinois, that's another 1968 special from Illinois. It's unconstitutional and still remains in effect, but you have to obtain a firearm owner's identification card prior to to owning possessing firearms. But you've got only a very small fraction of 1%. Not a small fraction of 1%, because technically it'd be 60% of 0.6% of people in Illinois now have registered these so-called assault weapons and signed these endorsement affidavits. So now when police come to your car and they run a plate, for example, and they can see that you're a concealed carry, and they ask you whether you have a firearm, and you are legally obligated to answer that in the affirmative if in fact you have that firearm on you, a lot of people are like, screw it again. I'll take my chances on a misdemeanor for not answering that, so I don't get charged with having a firearm that's considered an assault weapon that I didn't register. It goes on. There are a lot of different examples of why of practicalities. So yes, I have quite a bit to say on it, but go ahead and tell me what please ask me whatever I was going to.
Well, I mean, you could be for people that are maybe for the first time, either they're new to firearms, maybe they're considering it. I asked our last guest, beat cop for many, many years, detective for several years, being what you know from your vantage point of that experience, how do you feel about people taking on the significant responsibility of arming themselves? And so I'm asking you the same question, knowing that there's this quagmire, which is even exacerbated by the current climate that we're in. So we don't have a legal system right now that even is like sort of dealing with the issue fairly, if that's even a possibility anywhere. But we have actually the opposite, whatever the opposite of that is climate-wise. That's what we're experiencing right now in Illinois. So you got people out there that are making a decision about whether arming themselves is something they want to do in their lives. What would you tell them?
So
he said, just so you know, prior guest Carl Gray.
Great guy.
Yep,
very knowledgeable.
absolutely.
Very knowledgeable.
He says, well, what are you waiting for? I wouldn't hesitate at all. What's your take on it?
I think that, as I said earlier, we have something when I'm dropping these videos, because it takes a bit of effort to drop videos, just like it takes a bit of effort to this podcast.
How do people see
You guys are listening in, don't have any idea what these guys walk in with. They come in with the arsenal of different stuff. It's all over. It's taking over my office right now. But this is it's pretty fun, wires everywhere to make sure that you guys get the best type of sound here. But it takes a lot of, it's a lot of commitment, obviously. You guys drove out here. I drive these different places. I give lectures. I've lectured in front of thousands and thousands of people, and a good bit of the 2A community, at least local, at least this state, and certain other states are very familiar with just how much I give lectures. I've never charged a dime for giving a lecture on this stuff. I told you guys this previously before we had started the recording. I never charge a dime because of how much I believe in doing this stuff. I spent time here tonight, and I have a very crazy schedule, guys. Everybody, I don't say that to demean or take away from anybody else's schedule, but I have, my life is I'm constantly on trial, one trial after another, where the stakes are very high, where people might not, where people are looking at the possibility that they might not ever see their family except from behind bars or during certain visitation hours for the rest of their life. And in certain states where they could potentially lose their life from the charges that I and my office represent people on. So when I say it's a crazy schedule, it's not a 9 to 5 thing, guys. I don't leave the office and shut down for the day. I don't have that. I don't have the luxury. Right. I carry this with me because people trust me with such a significant weight.
Yeah, it's huge.
And I say that just to say, because last night I was giving a lecture the day before I was asked to give a lecture. I just got back into town on Tuesday, and I'm given two days in a row being asked to give lectures, and then now being asked to be on this podcast, and I'm not getting paid for it. And the reason I say all that in response to your question is because I think that if I'm giving people advice on what they should do, it's exactly what the hell they're doing right here. It's tuning in to these types of programs, these types of forums where people can talk about this. And there are differences of opinion, and you guys discuss the significance of talking to different people and opening their doors to people so you can hear their opinions, so that people get a 360 perspective of what's going on, because there's so much ignorance surrounding firearms out there. But my answer to you is, my advice to those people is, arm yourself. This is what we call it. It's called armed with education when we do a lot of these things. Armed with education. Arm yourself with the education. Arm yourself with the education. People think, okay, well, I've got my concealed carry class. Again, you're not proficient in this now. You have a baseline, mandatory baseline education, information on what it takes to be concealed carry and to obtain your credentials. That's not what I'm talking about. Arm yourself with education. And the firearms instructors, and Carl, for example, is a great example of this. There are a lot of people that come to a lot of lectures that I give that have been teaching this, that have been doing this for years, that have been in the field, that have been in the military, that have been police, that have significant backgrounds in dealing with this in one level or another, that come to find out, because we all can learn from one another.
Absolutely.
All of us can learn.
I've learned tonight. That's why we're doing it. That's why we do this.
100% the point.
And so I think my answer, and Carl's like, yeah, get out there, and I appreciate that, because Carl's very passionate about what he does, and I think that's a good, that's a very good quality for him in general, because he wears it well. He's genuinely interested in this field. He's genuinely interested in making sure that people are able to defend themselves and have the necessary education and stuff to be able to do that. So, I'm a big fan of Carl's. But I think that we should urge people to get involved in groups, get involved in these types of forums, where whether they're speaking there and asking questions, whether they're just listening, whether it's through podcasts, whether it's in person, whether it's social media, whatever the situation might be. I think that there's a lot that can be learned from this. That's why I personally drop videos. I don't have a social media page for myself personally. I have the brand for the firm throughout the country is Not Your Typical Attorneys. So everything is hashtag Not Your Typical Attorneys. So it's easy to find us.
You can vouch for that, I think.
Yes, I appreciate that. It's easy to find us. And the Not Your Typical Attorneys portion, a good part of why the branding came about to begin with, why I started branding, the firm that way, and at its inception, is just because I want to be more relatable. I want people to learn. about the law. Generally speaking, when you go in an attorney's office, the only thing you know when you leave is the price. And I want people to understand what their rights are. I want people to understand, the law as best as they possibly can. People are like, well, a lot of attorneys are like, well, you pay me to know this. I know this. But then you're in the dark. You're going through this process in the dark. And when you're involved in self-defense shooting, it's scary enough. But to be in the dark and not really have any understanding what the significance is really it's that much scarier. So, in answering your question, because I can't give any 5-word answer, as you may have noticed, in answering your question, I would I would suggest that people get themselves educated as much as possible. If you're carrying a firearm, watch some. The videos I post, for example, are a minute long. You can find them on Instagram. You can find them on TikTok, which I felt funny about saying TikTok in the very beginning because it's just like, all the kids are doing it. And, the thing of it is, though, TikTok's not nearly as censored. There are a lot of social media sites that are extremely censored that you do something on firearms, it could be great content. It's not getting there because they're just like,
Right.
They're clicking the X box, So
I've seen it. Yep.
But I have these videos posted. You guys are putting these podcasts out. People need to just embrace the education. People need to immerse themselves in information. And that's scary at times because you got a lot of people out there talking about these subjects.
It is. It's not a feel. It's not a feel good. It's one of the things I run into as a trainer. What I run into as a trainer is when I try to keep my training as realistic as possible. And when some of my courses, I call them violence management, right? Because they're not solutions, right? There is no solution.
Right.
People don't like that, right? They want to even firearms instructors. They want to go to the range. They love firearms. They want to do their shooting holes in paper thing. And they look at it as sort of like an algebraic equation, like, this plus this equals this, and there's your solution. And you could feel really good going off the range and saying, wow, I did something that'll help me in my personal protection journey with what I did at the range today. And the reality is that's probably not it.
Well, it's two different things, right? You just aggravated your charge because if you're a good shot, you're getting charged with you're not getting charged with ag discharge or reckless discharge of a firearm. You're getting charged with ag bat with a firearm, attempt murder, or potentially murder, depending on how good a shot you are. So that's one thing, which I'm not saying is a bad thing, because if you are really in fear of great bodily harm or death, then you are, in fact, entitled to use lethal force, and lethal force is that force that can kill somebody. So it is what it is. Somebody decided to put themselves in that situation, they're attacking you. But, aside from that being one issue about it, when you are looking at it as hey, you want to say something about it?
I had some thoughts after you're done. Regarding what my opinion is on the question that he posed.
Well, I don't want to monopolize by any stretch. Go ahead.
So, where my position on it is that education is incredibly important. Being trained in how to use a firearm is also incredibly important. But I also think that you need to understand the law when you can discharge your firearm, what to do in the event that you actually have to discharge your firearm, about what to say to the police, what not to say to the police, who should call the police, all these different things that you should know to minimize your chances of being charged with a crime when you do, if you have to discharge your firearm.
I would say you'd not only have to know it, you have to be practiced at it.
So let me follow up
to
with
assume that just if I teach it in class, that you're going to do it in that high stress situation is probably
That's the
unrealistic.
second point that I was going to
You
make,
have
which
to
I don't want to
have
interrupt
had
Joe.
it practiced.
The second point I was going to make is it doesn't matter. Some people can train, but they can be standing right in front of the threat. The threat can be 10, 15 feet away, and as good as they are at discharging their firearm, because the emotional significance, the firefight significance, the takeover that occurs within the body, within the mind, and manifests itself physically, mentally, emotionally, psychologically, because of everything that they're experiencing at that particular second when they're discharging a firearm, they can still miss.
Yeah, absolutely. Absolutely.
What were you thinking, Joe?
So my understanding has always been if a person is involved in a self-defense use of a firearm, calling the police and reporting it themselves is a good idea. that reaction
Chuckles.
may mean elsewise something else. But if the statement to give to a responding police officer was, I discharged my firearm out of fear for my life, and I don't want to answer any more questions until my lawyer gets here. Is that in line with your thoughts, or?
You know, that'd be great if you could execute that properly, and the officers, you know, if there wasn't such a heated political climate about who's being charged and who's not being charged, things of that nature. But I would have somebody else call if possible. You don't, because when you call, there's going to be a recording of your call, and, you know, with all the emotion running through you, you know, you might sound tentative. There might be, or you might sound angry potentially.
So that phone call, that recorded phone call, can get picked apart and possibly used against you.
It absolutely would be used against you, most likely. And it's best, you know, to have somebody else call. But if you actually are the one, you know, say that there isn't anybody that you can have call the police that's present, you know, you should just call and say, you know, I need an ambulance and I need the police to be here. It's an emergency. Hang up before they start asking you questions. I would not ask for 2 ambulances. And Dave can break that down into great detail about why that's a terrible idea. But and as far as what you should say to the police, I would certainly not make any statements to the police. I mean, it'd be great if you could just say, you know, I had to discharge my firearm. I was in fear for my life or whatever. But unfortunately, that statement could be misconstrued. They're going to ask follow-up questions. There could be all kinds of different variables at play. And then your statements, you know, 90% of your statements might be good things to say, and the other, you know, 10% or maybe even less, that's what gets played at the trial. Those are the statements that get brought up at the trial that are taken out of context. It's best if you said something like, you know, I'd like to cooperate, officer, but I just want my attorney present.
Okay. Great advice. That's fantastic. I appreciate
The problem
that.
is, with that said, guys, there's so much gray in the discussion we're having, because you have what we're talking about, what's anticipated, and then what actually happens. So, you know, from what we're talking about in practice, this would be a good idea. In practice, this would be a good thing to say. In practice, this would be a good thing to do, or, you know, to omit, not to do, not to say. But and it's good in theory. However, when you're involved in these situations, there's so many different, there's the psychological significance of what's happening, as I said moments ago, and that's what disrupts everything. That's the disruptive factor, right? I mean, when you're involved in this shooting, if you believe that you're going to be able to, people are commonly asking me, what should I say, what should I say, what should I say, and no, ideally nothing. And then if you're going to say something, there are different things that I would say that it would be perfect for you to say. Do I believe in a real, true experience sense that somebody is going to say or do as I believe they should say or do under the stress of the situation? Joe, that doesn't even make any sense. I mean, for me to believe that somebody would be able to follow that advice doesn't make any. It's not rational for me to believe that somebody could be rational enough
Gotcha.
to remember,
Fair
retain,
enough.
and spit out what it is that they have to remember, retain, and spit out at the time. So it's a, from our perspective, because you're talking to defense attorneys, which is why you're talking to defense attorneys, to gain that perspective. From our perspective, excuse me, the more that somebody says or does, the more we have to be concerned about how that's going to affect the case. So one thing just in general that people can relate to have some sort of, because I don't like speaking in too much gray, just a bit more black and white, a bit more relatable. One thing, for example, is something called hearsay. Everybody's heard the term hearsay, okay? And everybody thinks that they know what hearsay is or have an idea what hearsay is, but hearsay is an out-of-court statement being made for the truth of the matter asserted. Does that make any freaking sense? An out-of-court statement being made for the truth of the matter asserted. If it makes sense, guys, then I have to question who's in my audience right now, because it shouldn't make any sense. It doesn't make any sense. There are many attorneys that don't truly understand hearsay. They've been practicing for 10, 20, 30, 40 plus years that still don't really know what hearsay. People argue, judges alike. People argue what hearsay is that have been practitioners in the field in one form or another for decades. Still argue what hearsay is and what hearsay isn't. And if it's not being made for the truth of the matter asserted, what is it being made for? And then you have to talk about all the rest of these different things. But I'm going to break down. I'm going to give the most generic understanding of what hearsay is. The most generic understanding of what hearsay is, and there's an exception because in the law, guys, if you don't know this already, and people that are listening don't know this already, there are exceptions to everything in the law. But let's just talk about the most generic way of saying what hearsay is. It's saying that somebody is in court testifying to something that was said out of court.
Okay.
That's the most generic thing for hearsay. Now, once you understand what hearsay is generically, then there are what we refer to as exceptions to hearsay. So an exception to hearsay, is when yes, we acknowledge that it's hearsay, but because of our law, this particular exception, this particular statement, what's being said about what was being said out of court, actually gets in during the course of a trial. Okay? Do you know what the most popular exception to hearsay is in a criminal defense trial when it comes to like the most weighing, the most significant exception is?
Can I guess?
Yeah, go ahead.
A statement given by the defendant?
Yeah. And not just a statement given by a defendant, a statement against that defendant's penal interest, a self-incriminating statement. That's the most popular form of an exception to hearsay. That's the most weighing form of an exception to hearsay. So I want you to understand this, because I try to make sure that when I'm answering questions here, just like when I'm giving lectures or putting these videos out, I want to try to make it so that everybody can understand and grasp the significance of what's being said. Because if you talk to me about building a car, I love cars. If you talk to me about building a car, I don't know a damn thing about building a car, right? I mean, I think that's sexy. I think you know how to build a car. That's great, you know how to build it, but I don't have a clue. So if you start telling me, well, I had to put this in, and I had to tune this up, I have no idea what the hell you're talking about. So for me as an attorney, when I'm talking about building a case or building a defense to a case, very, very much in the same way, it can be very confusing. A lot of stuff can be lost. So I try to break this down. I want you to understand what I just talked about hearsay and about the exception of hearsay. If you are being criminally charged and you spoke to the police about what happened, you're starting to answer all the questions because you believe truly you're the good guy, and you are the good guy. Excuse me. This whole excuse me. Let me just get a little water here.
And you're trying to be helpful and cooperate with their questions.
Yes, you're trying to be helpful, and you're thinking, hey, I have nothing to hide. I was being attacked. This guy's carjacking me. Whatever the situation might be, this guy just ran over to us to try to rob us. This is what happened. And this could be a career thug, guys. It could be a career thug, somebody that's known for robbing everybody, and you're still getting charged for shooting the guy that's trying to rob you when you're in fear for your life. That's the crazy thing about the system. But again, getting back to what hearsay is, you're now being asked questions by the police. You're not waiting for your attorney. You don't have self-defense liability insurance. You don't have an organization you're calling, or fortunate enough to have an attorney that you're calling to be able to go ahead and say, hey, this just happened. What do I do? Are you available? Any of that type of stuff. You don't have that. You don't have those resources because you didn't educate yourself, which is part of your actually what I recommend people. I recommend to people, get yourself self-defense liability insurance coverage with a very good organization. Do research. If you don't know enough about the organization, ask around about it. If you don't know where to ask, call me. I'll
Do you find your attorney first and have a relationship prior? Or is that a no-no?
If you're fortunate enough to be able to do it, but it's a please come back to that because I want to address that next.
Yeah, please. Sorry, I didn't mean to get you off track.
I'm the one that got off track. I get the circular speech skills, which are pretty ugly, but I do find my way back each time.
Yep.
But what I was saying here, and the significance of it is, if you give all these answers to police and you describe this, there are a couple of things that you have to be aware of. First off, if I was speaking to the police for hours, and 2 minutes of what I said out of those hours can be used against me. 2 minutes. And the rest of those hours is just beautiful stuff. It's like if I'm listening to it, I'm like, great, this is my client. This is a dream case for self-defense. This person's saying all the right things. This is clearly self-defense. Anybody gets to hear this. Guess what, guys? What I'm saying that's favorable to my situation Guess what that's called?
Hearsay.
Hearsay. What I'm saying that's not favorable to my situation, the 2 minutes that I just gave, and you guys have smiles when you're just understand the significance of this, and smiles aren't caught on microphone. But I mean, chime in anytime so your listeners are understanding just how substantial this is, because this is a wow factor, a wow moment.
Yes.
If I give all this great talk about it, and 2 minutes of it, so that if it's 4 hours, I've been talking. 3 hours and 58 minutes is beautiful. It's hearsay. Doesn't come in at court. The 2 minutes that can be used against me, there's an exception to. So as a defense, you can't listen. You can't let the jury listen to 3 hours and 58 minutes because there's not an exception to that, generally speaking. As the prosecution, you can point out the 2 minutes, so they don't even get to hear all the good stuff that surrounds that. They listen to this out of context. They hear these different things because it is incriminating. And that's the second point, because I said there are two things I want you to understand about this. That's first off, is the significance of hearsay. The second thing, though, guys, is that, are you guys book readers? You like books? You like
Absolutely.
reading books?
I love reading.
And both of you, Lee's shaking his head yes as well. I'm not a book reader. I felt the book's good enough to come with the movie. I got so much to go in my life. I just can't sit down and read a book. And I did say before this began, I jump around a lot. So, all joking aside, though, when you read a book, and you constantly hear this when you go to a movie, oh my gosh, the book was so much better. Do you know
Right.
the book is so much better? Because it's a blank slate, guys. You get to imagine whatever the hell you just read, however the hell you want. The people look however you want them to look. The scenery looks however the hell you want it to look.
Sure.
Everything you get to envision. And great, the better author, the better the author is, the more the more you get to work with the more specific that imagination is, and the more you get to have fun with that. But it's still your imagination. You don't see it. Somebody comes along and says, I want to make a movie out of that book. And now you're looking at through the director's eyes of what that book actually shows. Now you're looking at the people, you're looking at everything. So why am I saying this? It's because when you talk to people, if you're in a room with 3, 4 of your friends, I'm in a room with the 3 of you guys right now. I go ahead and tell a story about what happened to me yesterday. And assuming it keeps your interest, you envision it one way. Leigh, Paul envisions it a different way. Joe envisions it. So why am I saying this? Because when you speak to the police about a situation, the police were not there.
Yes.
They did not see the movie. They're reading the book in a sense. They're being told by you what happened. It is your narrative. You're the author. They're being told by you what happened. So you run the danger. This isn't the police are bad. They're trying to convict. Police are doing their job. I'm not a defund the police. This whole garbage defund the police. You want to see where that takes us? Tell all the police not to show up to work tomorrow. And if the point isn't made, then tell them not to show up the following day, because it's a matter of time before everybody's going to surrender to what exactly it is
Without
that police
a doubt.
do and what they in the significance of police. But what I'm saying is, and granted, there are some bad police. They're bad attorneys. They're bad teachers. They're bad. They're bad people. It's unfortunate, but it's a part of life, right? But what I'm saying is, I'm not faulting the police. The police are receiving this information the way they're receiving it. Now, people that have a police background also know this. You're not writing the report on the scene. You're writing the report later. You're taking some notes, you're jotting some notes down, and you're trying as best as possible understand what those notes are later, so you can formulate, so you can go ahead and author your report, your narrative, whatever the supplemental, whatever it's the initial or not. You're providing this information later. So now you've got your understanding of what happened based on what you were told, because you didn't see the movie, and you've also got a delay in getting it all out on paper. So clients are very surprised. Well, that's not what I told the police. That's not what I told the police. That's not what I told the police. Well, you know what? There's other circumstances at stake here. There's other things that need to be considered, and that's why the number 2 reason is that it's how it can be interpreted. It's not necessarily you're saying something like, yeah, I killed him, he deserved it, that's being used against you in those 2 minutes out of the 4 hours in this hypothetical. It's saying something that can be construed by somebody that wasn't there in a way that can be argued that it wasn't self-defense in the true meaning of self-defense as defined by the law of that particular state. And that's what prosecutors do. And that's another thing, guys, which is a side thing. Unfortunately, you know, I've been at this gig for a little bit. This is my 26th year doing this. But in the very beginning, we used to talk to people. We used to talk back in chambers, or behind the wall, so to speak, as people. And we have a lot of prosecutors' offices right now, a lot of prosecutors in general, that unfortunately have changed, that are kind of like, no, your client's guilty. Your client's guilty. We can't go back. We used to go back in the day, back in my day, okay? We used to go back in the chambers. We used to talk, and there might even be people smoking cigarettes or cigars back there. There might even be an occasional drink back there. You just go ahead and you just talk about the cases. You'd be like, hey, I got a guy that did something stupid, but he's a good guy. Is there's something we might be able to work out here?
There was,
they would say something
there
like
was an
that.
informal network.
Exactly. And it was,
and that you see that
the profession
less
doesn't
or
really,
gone?
Oh, it's damn near extinct.
Why is that? What
Yeah.
has caused that
Well,
change?
a lot of it, as it pertains to firearms, guys, a lot of it is again the political climate. It goes back to the political climate. It's whoever's in power, whoever's pushing whatever agenda. From the head prosecutor, what the head prosecutor wants. You don't want to lose your job. You got to fall in line. Another prosecutor takes over your office and they're pro firearm. As a prosecutor's office, that's not common in certain cities. In certain cities, it's damn near impossible to have a pro-firearm candidate running or successfully attain a position, a head prosecutor. But there's a lot of fear in stepping out of line, so to speak, and we can't speak rationally on these cases. We can't talk about we talk about a person where Paul was alluding to somebody we're currently representing. It's being held in custody right now that we're going to have another detention hearing on. And the judge was resistant to having a detention hearing. Why do you want me to have a detention hearing again? We just had a detention hearing before. Well, because this new law allows us to have detention here. We can have this. We can re-argue, re-litigate this issue of detention as often as we want. And our client's in custody. That's why we want to do it. I'm sorry it's inconvenient, but our client's in custody.
Right.
And our client's freedom is at stake, so we have to litigate this. And we've been successful in re-litigating these detention hearings and convincing the judges that we're not initially on board to release our clients. But you have a lot of different judges also that are very turned off. That really do not, that strongly disfavor firearms and people carrying firearms. We finished trials. I finished one trial in particular with a judge I very much respect. He's extremely knowledgeable judge out of Maywood Courthouse, and we finished up the case in front of him. It was an attempt murder. It was multiple counts of attempt murder and aggravated battery with a firearm. Very, very serious charges, and we got the not guilties. He was the one presiding over the case. We didn't go with the jury. I trusted him, rightfully so. It wasn't even a thing about favor or anything. It's just about you just search for judges that you believe are just going to be consistent and follow the law, because some of these cases are very difficult, and so you have to set aside your personal feelings and you have to follow the law. But we're done with the case.
So interesting.
He gets
interesting.
He gets a not guilty. He gets a not guilty verdict on all these different charges. I want to say maybe 13 different counts. Very significant.
Wow.
Very significant counts. He gets a not guilty verdict, and then the judge proceeds to really go in on him. Just say, hey, look, this is the problem with concealed carry. You guys are carrying these firearms, and you think you're police, you think you're superheroes, you think you can go ahead and do this type of stuff. But to his credit, because we may have a difference of opinion on the significance of concealed carry and
To the judge's
what
credit.
it means, to the judge's credit, he ruled in keeping with the law, not in keeping with, not based on his emotion, not based on his personal feelings, personal beliefs. To his credit, he ruled with the law. And also to his credit, there's a family that's showing up for the victim that's showing up all these different days, and there's the victim showing up as well who had 4 bullets enter his body. That's showing up every day as well, and he's giving a not guilty verdict on all these different counts with this family and this inherent pressure from people that were obviously affected by this. Right or wrong, the family wasn't there shooting, and they have their family member there, and they're wondering why isn't somebody getting convicted because you just shot up my son or my brother or whatever the situation might be. So, guys, there's so many layers to this, guys, that it's, as I told you before we started, I mean, we can go on for days just exposing, different problems in the system, different problems in the law, but it goes back to
that's very clear.
What you were asking me earlier, Lee, what goes back to is just like, what would you recommend? It's educate yourself.
Mm-hmm.
Get and that's another thing for the USCCA, to their credit, is they provide all this training and all this education. And in a lot of the lectures I give lectures for all these different, you guys were referred over to me by ISRA and by certain, firearms instructors, whether, that not even USCCA, some USCCA, some not USCCA affiliated, they're referring you. And I give lectures for all these different gun groups and organizations because, again, I believe in it. But one of the things that's being done when you're giving the lectures, you're learning all this stuff at for close to nothing. I mean, if you have a membership with these organizations, for example, the USCCA, that their prime membership, their top membership is less for an entire year, is less than 1 hour of my time.
Yep.
Let's just put that in perspective, guys, because we've been sitting here for a little while now talking. These lectures I go and talk at, these different groups I go in front of, these different other engagements where I'm trying to go ahead and spread the good word, so to speak. And I'm not taking any money for it. Take advantage of that. If I wanted to get in the cars, I'd take advantage of if there are people that just wanted to provide that information for free, because it costs money. People don't want to part with it because they feel, and it's in a sense, guys, for what we do, for what I do. I mean, our firm does a lot of injury work, but me personally, this is my niche. This is what I enjoy doing is representing the good guys after they've been involved in bad situations, and it's a great feeling doing it. But at the same time, like I said earlier, the weight that's on your shoulders, it's immense. It's very significant. But take advantage of these different pockets of information where you can be provided this wealth of knowledge from different people. I'm not talking about myself right now. I'm talking about in general. Just seek out where you can go ahead and gain this information. Get self-defense liability insurance coverage. It makes no sense to carry a firearm and not have somebody that's going to defend you after you've defended yourself. I mean, think about that. You don't leave the house. Wanting to get in a car accident, and that's why you get car insurance. You just know you're driving a car, so you have to get car insurance. It's the same damn thing. You don't leave the house saying, I hope I get attacked today and I have to shoot somebody. At least normal people don't leave the house feeling that way.
It's one of my bottom line recommendations. It has been before I became affiliated with USCCA. I was like, over the course of the first year or so that I was doing this training, I was like, this makes sense, because when I worked in protective services, we have plans for what we do after a significant event. And if you as a civilian don't have a plan for what you do after your significant event, you really don't have a plan. Your plan's incomplete.
Exactly.
And most people don't have a plan for what happens after.
It's so powerful.
Yeah, it's huge.
And to be able to afford competent representation on these significant cases involving firearms, the legal costs are astronomical to a lot of people. And, the amount of effort, the amount of time necessary, because a trial is your one shot, right? If it doesn't go the way that you want it to go, that's potentially your life. And so the amount of preparation involved in that, the amount of discovery
Has to be immense.
Right. You can have cases that could literally be over 100 videos, of all body cam, medical records, all kinds of stuff that take hours and hours and hours just to get through. And that's not even, when you're talking about, it's not even counting trial strategy, prepping, for your testimony, prepping other witnesses potentially to testify. That's why it's really important to have a self-defense plan in the event, that you have to defend yourself or another person.